And good morning, everyone. Welcome to day 4 of Defense Academy. We really appreciate everyone who's continuing to tune in the morning and to apologize for that little interruption. I had to mute the mic on my YouTube feed. Anyway, I appreciate everybody who's joined us now for the 4th day of this incredible programming. We heard from Chandler yesterday about cybersecurity maturity model certification, as well as software integration with FedRAMP and how to get to an ATO, authority to operate. As dense as those subjects are, and quite frankly, they can be a little less than interesting. But Chandler certainly made the topics come to life, and we really appreciate him for coming. So today we have an even better lineup of speakers coming to you. I want to apologize to the audience for John Serafini. John, he's an absolutely great guy. He's my West Point classmate. I've known him for 25 years. He's traveling in a relatively remote area as a busy startup founder. Those things tend to happen, and his Wi-Fi went out. So he was driving around in his car trying to connect to a cell tower that would be good enough to handle the platform, but it just wasn't working out. So we gave you 30 minutes of your time back. Hopefully you guys are using that time to grow your startups and your business. But we're going to hear in a little bit from Janna Lewis, who's a senior intellectual property attorney, innovation strategist, and just a basically amazing human being. And then after that, we're going to hear from Heather Richman from the Defense Investor Network, and she's also a principal with BMNT. So why don't we go ahead and introduce Janna? Good morning, Janna. Thank you for joining us. There you are, in an office with a Wi-Fi connection, maybe even an Ethernet cable, and and all ready to go. It's really my pleasure to introduce Janna to y'all. So Janna's an innovation strategist. She's an intellectual property and government contracting guru. She currently serves as corporate counsel for Northrop Grumman, but she's worked for tech giants like Facebook and in private law practice. She's a member of the Federal Patent Bar, which anything who knows anything about the practice of law, particularly in that field, knows that is an achievement. And she's also a regular in government innovation circles such as GovCity, which is where I first met you, and we have become friends and collaborators since then. So Janna, we got a great audience. We've already actually, I think, got a few questions in the chat, so people are interested in hearing what you have to say, and I will not delay them any further. Thank you for being here.
Right. Hey, it's my pleasure. All right, let's get some slides up. Okay, and thank you, Kevin. Really appreciate being here. It is always a pleasure to collaborate with the Capital Factory and of course, to connect with this terrific Defense Academy community. As Kevin said, I am Janna Lewis. I am Senior IP Counsel at Northrop Grumman. And part of my job is to help defense contractors form strategies for developing and deploying their technology to U.S. government contractors. So for the, 50 minutes or so, we're going to talk about what is probably one of the most perplexing topics in government contracting, and that is intellectual property and data rights. Now, this is an area of concern for everybody, whether you're new to contracting, whether you are a traditional government contractor. It's a tough area because it's always moving. But if you are just getting started in this space, just getting started and working your way towards your first U.S. government contract, this session is designed for you. We're going to keep this very high level. There is no way we're going to get into all of the details of intellectual property and data rights in government contracting. But the goal here is to give you kind of an awareness of the issues, of the terminology, and provide you some pointers for working your way through this ever-moving topic. Now, of course, this would not be an authentic session with a lawyer if I didn't drop in a legal disclaimer. So basically, I'm not your attorney, not giving you legal advice. If you've got questions that are particular to your circumstance, please find an attorney, someone knowledgeable in this unique field, and someone who isn't me today. So let's get started. We're going to work through this deck and talk through these basic principles. So like I said, we're going to do an introduction to data rights principles. Be aware that we'll talk through data rights from the perspective of FAR and the DFARS, but we're really going to focus on the DFARS, the Defense Federal Acquisition Regulation Supplement. So this is Defense Academy. I'm presuming everybody here by and large is working on defense-related contracts. We will focus on the DFARS. The FAR has some important differences in the data rights field. So if you're doing civilian contracting and you've got some questions, towards the end, if we have time, we can maybe get to some of those, but be aware, DFARS specific, DFARS focused. And in working through those fundamentals, we're going to set a baseline. And with that baseline, we can then jump into what are technically and quite literally deviations to those basics that appear in SBIR and data rights under the SBIR policies. Now, I hope to, and in fact, I'm going to make sure that we have time to go through some important changes. There are old and a recently issued new policy and language around that will affect you if you are pursuing SBIR type contracts. And then I am really hopeful that we're going to have time. We're going to get into the DoD instruction. Now, whether you are new or experienced in government contracting, this is going to be important for you to know because the U.S. government is aware that this is a tough area. The U.S. government customers, they are really trying hard to find a path forward to adapt their acquisition and licensing principles on data rights topics to help contractors and find an equitable place for both parties so that we really as a whole can move forward and provide capabilities to the warfighter. Now, just as important of what we are going to cover is what we are not going to cover. It's important to have this in your mind because one of the key areas where people kind of get tripped up when we're talking about intellectual property and data rights in government contracting is really what does it mean? And know that when we talk data rights, we are not talking about patents, subject inventions, or trademarks. Those are covered in their own regulations and they're relatively straightforward. So once people understand that, they tend to not be tripped up so much about that. But keep in mind, as we work through these principles and work through this language, we are not talking about your patents, subject inventions, or trademarks. We're talking about everything else. We also are not going to cover commercial items, COTS, or a GSA contract. So this is all non-commercial. This is all information, data, and technology that excludes patents and subject inventions and trademarks. So because time is short, what I did is distilled these concepts into some really quick takeaways for you. Now, this is up front, what are we going to call it? Bottom line up front, or TLDR for you, so that you can have these concepts in your mind as we work through what really are going to be kind of complex principles. So look through these, keep them in mind, and we're going to talk about them a little bit more. These are the keys. These are the essentials for protecting your IP and your data as you're interacting with the U.S. government, contracting and performing under contracts with DoD government customers. And it's essential that you know your technology. Maybe you're there saying, yeah, of course I know my technology. It's more than just being aware of what you brought to the table. You have to be able to identify it. You have to be able to describe it. And you have to be able to really clearly differentiate it from everybody else's. So identify your proprietary technology and make sure it's yours. And you also will need to be able to identify that technology that you're bringing to a government effort and contrast that, distinguish it from the technology that you're going to develop during a U.S. government effort. It's a funding issue. We're going to talk a little bit more about it. So know it, know your technology. Then be able to track your technology development. This is where the strategy comes into it. So during development, evolution, or integration, whatever might be happening with the beautiful creations that you're going to bring for the U.S. government, make sure you're tracking it. Make sure that, again, you can differentiate it from the other technology that may be in a particular environment, and make sure that you are carefully tracking your funding sources for each of those items and components. Then market. You need to mark everything that you provide to the U.S. government. It is a cardinal rule of data rights protection, because if you don't, you are very likely going to lose your ability to control your technology. So make sure you're marking it, and make sure you're marking it using the required notices or legends that are set out in the DFARS regulations. We'll talk a bit more about that. And then be ready to prove it. More and more these days, the US government is coming back to various customers saying, hey, you tried to limit my ability to use this technology because you've asserted certain data rights. Now prove it to me. Prove to us that you have the ability to maintain those sorts of restrictions. So it comes down to maintaining your funding and development records and be able to substantiate those restrictions. We're going to get into those as well. So keep these in mind. As we talk for the next, 45 minutes or so now, we're going to talk about where these come into some of these essentials and high-level pointers that we're going to provide. Know it, track it, mark it, prove it. So let's talk about terminology. So far, you've heard me use a lot of different words. I've used the technology, I've talked about intellectual property, I've said data, I've said data rights. How does that all work together in this strange world of US government contracting? For purposes of this high-level session, I put it out in kind of formulaic way here that seems to resonate, I think, with a lot of the engineers that I work with. Essentially, your technology, these creations of the mind, these unique technology ideas and creations, if they give you a competitive advantage, they are a competitive differentiator for you, then it is very likely that that is going to fall into one or more legal constructs for intellectual property. That'll be like copyright or trade secret or other proprietary categories. But be aware, we are not, again, talking about patents or innovations. For purposes of this, we're talking about intellectual property that extracts those. So take that IP and put that through that sort of magical prism of the DFARS regulations, the clauses, and on the other side, you get data. Your intellectual property, that technology that gives you a competitive advantage, becomes your data. It's the same stuff. It's just called something different. Intellectual property is not a defined term in the DFARS. It becomes your data. And then the DFARS takes that concept of data and breaks it out into two different categories. It becomes technical data, which is recorded information, technical information, like design drawings, other things that are actually recorded in writing. And then computer software, programs, code, algorithms. These are the two primary types of data that are covered in the FAR and the DFARS. And your US government customer is going to treat all intellectual property or technology that you provide to them in performance under a government contract in these two categories. And they will interpret and treat your rights, the rights that you grant to them in these elements, technical data and computer software, according to very specific schemes that are set out in the DFARS clauses. So your technology is intellectual property. Your intellectual property, when applied to the US government environment, and DFARS in particular, it's called your data. And then that data is broken up into technical data and computer software. So one of the things that I hear all the time, and this is from everybody, no matter how long that they might be working in the US government environment, is who gets what. It is a confusing area. It is difficult, but there are beliefs and interpretations that essentially, when you're working with the US government is going to take, I even hear the word steal, intellectual property and data. And by and large, that's not the case. In fact, the US government doesn't take ownership in intellectual property or data that is provided by contractors under their US government contracts. There are a couple of exceptions that are so rare, not even going to cover it here, but essentially you will own everything that you create under a US government contract. This is true even if the US government pays for the development. As a contractor, you will own everything that you create. And certainly you're going to retain ownership of everything that you might provide to the US government in the course of performance, stuff that you might have paid for out of your pocket and then developed, and then you're bringing it to bear in performance in a government contract. This is true under the standard DFARS that we're talking about. When we get to it later, it's true for SBIR. This is always true. You will retain ownership. So you've got ownership of your intellectual property and data, and the US government, they receive license rights. to that data. Now, the question is, what's the license right? What is the scope of that license right? And just like the commercial world, the scope of a license granted to somebody in intellectual property or here in data is dictated by a variety of things. There's a spectrum of those license rights. And that scope depends on quite a few factors. But the key one when we're talking DFARS is the source of funding. So if you paid for the development of technology or data, then you get the right to restrict the US government's use of that in very significant ways. We're going to talk about that spectrum in just a moment. Now, the other thing that can influence this is whether and the degree to which you have identified your data up front at the proposal stage. This is a critical part of working with the US government, is putting them on notice when you're going to restrict their use of a particular technology. Another factor is going to be how you marked it. Like I said before, marking is critical in working with the US government, and there are very specific rules around that. And then the next part will be those negotiations. Now, this is, again, something that some people don't really implement because it's a hard thing when you're working with the US government, but in the world of data rights, it's negotiable. Data rights are negotiable. Not everything in US government contracting is, but data rights are. You can negotiate, you're empowered to negotiate, and more the US government is receptive to that. Now, another thing we're going to talk about would be the legislation policies. This area, data rights, US government contracting for intellectual property data rights in both basic DFARS world, in SBIR, in the world of OTA, which maybe we'll get to if we can, it's changing, and it's changing really, really fast. So watch it, be vigilant, stay engaged. So we've got to the technology. We've talked about who gets what in a very basic sense. Let's talk about how do you know? How do you know what the data rights clauses are, what they say, and when they may apply to you? US government contracts are weird. They're this big stack of paper with a lot of terminology and acronyms and cross-references throughout. And particularly when we're talking about data rights are scattered often throughout a document. But by and large, your data rights principles, so again, data rights being the rights that the US government will get in the technology that you develop under a contract, those will be set out in the data rights clauses. They are often incorporated by reference within the contract itself. So you'll see a line item that says, in the context of DFARS, the 252, 227, and then it'll have the data rights clause right after that. Those then refer to the regs and sometimes very long terms, language that then sets out the provisions that will be incorporated by reference into your contract. They're often not set out in your contract. They're set out in those clauses. So it's really important to understand those, and maybe sometimes painful, but I do encourage people to read them so that you understand the terminology and the principles behind that. We're going to talk a little bit about some of them, but it's always a good thing for you to do. Another thing to be aware of is, in addition to those clauses that are incorporated by reference, there are additional and different terms, more and more these days, in fact. They appear in the H clauses. H clauses is a section of a contract where you get different or special clauses. Sometimes the data rights language shows up in a statement of work alike. This is something that really underscores the importance of reading your contract. Read the whole contract. I tell my programs and teams, go through it, look for 227. Go through your contract and do like a control F or a find or a search on the word data or deliverable or rights, because it'll take you to language that may have some strong bearing on what the scope of that contract is really going to require of you and the types of rights that your government customer is going to expect. So these data rights clauses, as I said, they talk about definitions. They have the notice requirements. They have, again, the marking language for data deliverables. And that is an important concept for you to be aware of. The data deliverables set out the expectations of what your government customer wants you to provide to them. So you need to know what those are. You need to know what the expectations are, and you need to know how you're going to address those. So again, the US government will only get rights, so their license under the DFARS, they only get rights in what you are required to provide under that contract. US government isn't going to get a license right under the DFARS to anything that you create outside the scope of the contract and that you do not deliver under the contract. It's a delivery model and it's unique to the DFARS, and it's not true under the FAR. So be aware that knowing what those data rights clauses are and what the data deliverables are is a really important thing for you under DFARS type contracts, under SBIR type contracts, OTAs and the like. Now, again, your ability to limit the scope of those data rights that are set out in the contract that we're talking about really modulates according to whether or not you paid for it. It's a funding question. And so if you paid, you get to the limit the US government rights. What I really want you to know when we're talking about DFARS, and this again is true for SBIR, is that data that you develop with mixed funding, where you have taken your private expense technology and you've mixed that technology in a way that is not distinguishable from your original technology using US government funds, you end up in what's called a GPR world, government purpose rights world. And after a set period of time, that becomes unlimited rights. So this is really important for you to be aware of at a high level. Look for those data rights clauses, know what they are, know what your data deliverables are, know what you're bringing, and know who paid for it, because that will influence your data rights and how you move forward in performance of your government contract in protecting your data rights. Now, these data rights clauses that show up in the contract, prime contractors are required to flow them down to the subcontractors. This is an important concept for you because subcontractors' data rights flow directly to the US government. Your prime is not allowed to take data rights from you that should be going to the US government. That is a separate negotiation if it's going to happen. So be aware, you as a subcontractor, many of you might be subcontractors right now, your data rights flow directly to the US government, and your prime cannot condition the award of a contract or other sorts of benefits on your data rights allocation there. So we've talked about the terminology, we've talked about ownership, we've talked about data rights clauses governing the allocation and where to look for those data rights clauses in a standard DFARS type contract. But oftentimes people wonder, so where are you going to go to understand the scope of it? This is a spectrum of the data rights protection. I know this is a dense chart and we're not going to linger on here, but I wanted to drop it into this deck because it'll help you understand in a visual way what that spectrum of data rights protections look like. So limited rights, that covers technical data, restricted rights, computer software. And if you paid for the development of that technical data or that computer software, you get to significantly restrict the US government's use of it. Then you'll notice down towards the bottom, unlimited rights. That's true for technical data and computer software as well. Unlimited rights, basically the US government can do whatever it wants with unlimited rights data. If you provide something to the US government, or you use government funds to develop a technical data or computer software, the US government will have those unlimited rights. And when I say if you provide it to the US government, I mean without a restrictive marking on it, without giving them notice that you intend to limit their rights in it. The US government can then say, well, thank you very much. We appreciate your contribution to the warfighter. And then they can go on and hand that over to whomever they want in any manner that they want, including for competition purposes. Now in the middle, you'll see specially negotiated license rights and SBIR rights, as well as GPR, government purpose rights. We're going to talk a little bit about each of those, but be aware, these are the data rights categories that you get to use and rely upon often when you're dealing with the US government. And these are the data rights categories that your US government customer is going to be looking for. They're not going to look for patent. They're not going to look for copyright or trademark necessarily, or trade secret. They're going to speak this language. And this is the way that you really can work to protect your data as you're interacting with the US government. So you remember when I was telling you up front about know it, track it, mark it, and prove it? The first time that you're really going to be asked to implement those concepts often comes at the proposal stage. Now, I would argue it comes before. If you're doing private expense investment in technology development, that track it part kicks in there because I want you to document it. But usually when you're engaging with the US government and you're looking to provide technology or technology-related services to a government customer, the first time you're going to interact with this is at the proposal stage. And this is that point in time where you really, really need to think about what IP and data the US government is expecting under a particular contract. Again, you've got to read the contract. It's sometimes hard, it's sometimes painful. You might need help in parsing some of the language in there. Reach out. I mean, Capital Factory can help you. I think with some of that, you can look to other resources or go to an attorney if you have questions about it. But reading the contract is essential. And then look for those data deliverable expectations. What is the government looking for in the context of this contract? They usually appear in CDRLs, the contract data requirements list, SDRLs, which would be subcontract data requirements, the DIDs for the data item descriptions, statements of work, etc. Like I said, be very thorough in going through your contract and understanding what does a US government customer expect you to provide in the way of technology or data if you are paid to perform under this contract. Don't get caught off guard. It happens a lot. It happens a lot where programs or companies fail to see what the government has an expectation. They've locked themselves into a contract. The government is paid a price. The government expects delivery. So make sure you know what you're on the hook to provide. And if you're a subcontractor to a prime, make sure you're thinking that through in the context of your teaming agreement or your NDA, or if you've got a side license agreement. These are important things to think through as you're negotiating them and working with primes on the subcontractor side. So you're going to look through and you're going to find out what IP or data the government expects. But then you've got to know what you're going to provide. Now, sometimes maybe your plan is to use clean slate. You are going to accept entirely government funds for the performance under a government contract. In that case, there's not really much of an issue. The government is paid for the development of that data. The government gets unlimited rights in it. You still own it, but the government gets unlimited rights. They can do whatever they want with the data that you create. However, if you're introducing any privately funded IP or data to your performance under a contract, then you have to put the US government on notice that that data is coming with those restrictions. If you fail to do that and you later try to assert a restriction on data that you provide to the government, you're going to be in basically an uncomfortable situation, and you have a high likelihood that you will lose your ability to protect the data because you failed to identify it upfront with those restrictions. And the place where that happens, again, is at the proposal phase. You've gone through your contract, you've figured out what the data deliverables are that the government is expecting, and you then are required to identify those privately funded data items in what's called a data rights assertions table. I call it a DRAT because that's usually the response I get from people when we talk through this, because it's either DRAT, I have to do that because it's hard, or it's DRAT, I failed to do that, and now you're in some big trouble. So the data rights assertions table is the place that at the proposal phase, you enter in the data, the IP, the technology that you are going to introduce in performance of a contract, and you're going to put the US government on notice that you plan to restrict their use of it according to that spectrum that we talked about before, using that language. So this is the know it phase, right? This is the know it. Know what you're bringing, know what's required, know your technology. If you do, you're miles ahead, right? If you're able to do that and provide it in a succinct way. This is also the place, hopefully earlier, but at a minimum at the proposal stage, is where you've got to think through your IP strategy and track your data. Think through what's going to happen with your intellectual property once you introduce it for performance under a government contract. There are stages of development that IP might go through, that data might go through. And development is a defined term. I wish we had time today to get into it, but be aware, look at the DFARS and understand what it means to be a developed technology, developed data, because that can influence your strategy and the way that you think about the point in time when you were going to convert from privately funded technology development and then turn to acceptance of US government funds for improvements to your IP assets. There's an important line there that will help you maintain your rights even as your intellectual property evolves through performance. So anticipate that evolution. from that IRAD or the early R&D stages, performance, think through it, delivery to your government customer, all the way through sustainment. Because as we're going to talk about a little bit later, your government customer is going to be doing this. And you need to be ready to walk side by side with your government customer on that IP side of things. And then really work hard to keep your privately funded technology separate from technology that comes from other funding sources. Remember when we talked about GPR and that mixed funding scenario? If you mix in that other funding with that development side of technology, you run the risk of losing your ability to control your technology and your data and dissemination of that. And again, I'll say this more than once, data rights are negotiable. So here again, know your technology, track your technology as it moves through that, because your awareness of that is going to help you support your data rights and maintain both your competitive advantage and your ability to commercialize that data moving forward and controlling that and keeping it from your competitors. So we've talked about the proposals. We've talked about, the importance of doing this data rights assertions table. This is one area that tends to be really hard for everybody, the data assertions table. It ties into that know it concept, but it's also one of the most important of two most important moments where you have to identify data rights. And I put those bookends here in this slide. The first one is what we're talking about right now. At the proposal stage, you need to enter in your data rights for your data in that draft, the data rights assertions table. It is literally a form that is in the DFARS that you fill out using that prescribed format. And you send that in with your proposal so that the government is on notice, or in the case of subcontractors, your prime is then on notice of your data assertions. And then your prime contractor has an obligation to turn around and hand that data rights assertions table over to the government customer. They can't change it. So if you are working with a prime under a standard DFARS contract, and this is also true in many SBIR situations, your prime can't modify it and they can't force you to modify it. Hopefully you've got it right. So sometimes your prime will come back, and I do this quite a lot in my position as I come back to a sub and I'll say, listen, thank you for your data rights assertions table. You've entered in information that you might want to rethink. And then I'll hand it back to them and ask them to redo it, because everybody wants it to work. Nobody wants delays that come from improperly formatted data rights assertions table. So take the time to fill it out properly. Take the time to know and understand what technology you're bringing in that's privately funded, and fill out that data rights assertions table according to that data rights scheme that we talked about previously. And that information is in the DFARS. And be sure to ask for resources. Now, in that data rights assertions table, again, you're putting the government on notice of what privately funded technology you are going to bring. And you're saying to the government upfront, don't use this in a broad way. For technical data, certain limitations apply, and they're pretty strong. For computer software, certain limitations apply in the form of restricted rights. They're really strong. So make sure that you're giving the government notice on that, because in the end, you remember those two key moments. When you turn around and you're ready during performance to hand over that data that you've identified up front, you have to mark it. And you have to mark it with data assertions that match the entries in your data rights assertions table. Quite literally, your prime and then your government customer, they're going to take that data rights assertions table, they're going to look at the data deliverable that you've just provided, and they're going to compare. And if they don't match, you're going to have a problem. So two moments, call them bookends if you will. At the proposal stage, data assertions. They have to match the data markings that you provide on delivered data later. So only do privately funded data. Don't give the government data that it didn't ask for. That goes back to reviewing the contract and finding those contract deliverables, and then identify it, all of your data at the lowest segregable level. This topic of segregability, silly word I know, but segregability really means making it distinguishable at practical levels. So you've got a computer program, break it down according to funding source if needed, by module, by different files or folders if you need to, but by funding source. Make sure you break it down appropriately according to who paid for it. And then, of course, use those proper data rights assertions that tie into it. So restricted rights for computer software, limited rights for technical data, GPR, SBIR is its own marking, and then specially negotiated license rights, that negotiable aspect of it that you're always empowered to do. And again, if you aren't sure at the proposal stage when you're making these data assertions, if you're not sure what you're being asked to provide, please make sure you're talking to somebody about it. Ask your CO if you have access, or go to your prime if you're a sub, or at the very least, consider using assumptions in your written proposal. And by that, I mean, we are assuming that we are only going to provide, for example, source code or executable code, and to do the appropriate assertion for that. You can make those assumptions, but make them clear if you need to. But I always encourage that conversation, and hopefully your government customer is going to be open to that as well. So we've talked about the proposal stage, how the contract is framed for data rights. We've talked about the importance of the proposal stage for doing your data rights assertions table or draft. You've gone through performance, right? You're now entering performance, you have your contract award, and you need to turn this data over to the government customer. So in that mix, we're presuming that you are introducing privately funded technology. Because I said, if all you're doing is creating technology from scratch, not using any external technology that either you own or a third party owns, and it's just fresh blank page technology development using government funds, this is less of an issue because your US government customer will have unlimited rights. However, if you're introducing data that you want to preserve from dissemination and control and keep away from, for example, competitors or others, it is critical that you properly mark that data. It can't be overstated how important data marking is. Now, the DFARS itself permits two types of data rights markings, right? There are the prescribed legends that are in the DFARS, and if you go to it, you're going to see them written out there, quite literally typeface with little blanks that you're supposed to fill in, and those legends go on every data item that you deliver. Now, the other marking is a copyright notice. Under the DFARS, you are allowed to add a copyright notice to copyrightable material where you are the original author. It's not true under the FARS. Sometimes you need permission, but under the DFARS, you are allowed to add a copyright notice, and your government customer and your prime cannot force you to remove that. So be aware of those two methods of marking data, ensuring that once it goes out, others are on notice that that is proprietary to you, that it's your technology, your IP, if you will, and they realize that there are restrictions that come with use of that data. So I often get questions on how to mark and where to mark. You need to mark your deliverable data with everything that you're going to send over with greater than unlimited rights. Those, as I said, those markings have to match those entries that you've put in your data rights assertions table. The markings have to be conspicuous and legible. You can't make them like itsy bitsy 0.5 font, right? Or, in places where your government customer isn't going to see them. So you have to be thoughtful about it. Get into the minds of your government customer. What are they going to see? How will they encounter or interact with your data? And make sure that your marking is visible to them so they're aware of it. So for technical data, remember, technical data is that written or recorded technical information like drawings and manuals and other sorts of printed technical documentation that is proprietary to you. You have to mark every page. You can't just mark the first page. You have to mark every single page with a limited rights data notice. Now, sometimes you might be handing over a drawing that has limited rights data because it originated with you. You paid for the creation of it. And then maybe over here, you've got an aspect of the drawing that either belongs to somebody else or that the government paid for the development of that. You are allowed to portion mark. And to portion mark, you can actually happens a lot. You can take a marker or a pen on that drawing, or if you're on the computer, set a line, annotate it and draw a little squiggle or other way to portion out that aspect of the data that is differently marked. You can have limited rights on this marked side. You could have it not marked on the other portion marked side, which would tell the US government it's unlimited rights there. So think about how you're presenting it, making sure that your markings really align with where your private funds go and that you're using the proper markings, the ones that are dictated in the DFARS. For computer software, that tends to be a little more challenging for people. You are allowed for computer software to mark on the storage container. For these days, to the extent anybody's like handing over, CDs or discs, you can put the data rights marking on that. If it comes with some sort of transmittal document, you can put the marking there. Oftentimes, you can put it in a README or a header file if your government customer is likely to encounter the marking there. But what's key in the case of computer software is you can't put a marking in a place where it's going to interfere with the operations or use of that. And I want you to think of like, you've got some super cool avionics, heads up display. The last thing your government user is going to want is, a data rights notice showing up on the screen and blocking view. So make sure that wherever you put these markings, it's not going to interfere with use. Make sure it's, conspicuous and legible, but also allows appropriate use. And again, cannot be overstated. If you don't properly mark your data that you want to protect, you are basically saying to the US government that is going over with unlimited rights. You will likely lose your ability to control that data, and the US government will be able to hand it over to your competitors or others, and even take your data and say, here, competitor to the original creator, I'd like you to take this and I'd like you to tell me how much you will charge to provide the same material to me. They can use it for recompetition and basically boot you out of your position. It happens more often than we like to think, but it's there. So again, we're going back to our topics. We talked about know your technology, what you're bringing, track your technology as it's evolving through, mark your technology, know it, track it, mark it. So here's the prove it part, because again, know it, track it, mark it, prove it. More and more these days, our government customers are challenging data rights assertions. For any of you who maybe have been working with US government customers for years, you'll know 10, 20 years ago, data rights really wasn't much of an issue. It really was not top of mind. It is now. Our government customers more and more are coming out and saying, listen, we saw this data rights notice that you put on. We challenge that, and we want you to prove that you are entitled to restrict our government customer use of this data. It is really important that you keep adequate records and substantiate your data rights assertion. And what that means is records of development, records to show that you or someone else, that there was private funding used to develop that data. So if the government customer comes back and says this marking is unjustified or non-conforming, you have to be ready to respond within very strict amounts of time. Now, an unjustified marking, of course, is it's not supported by the data rights assertions table. What we just talked about before. The government customer has done that match that we talked about and came back and said, yeah, it doesn't match. Unjustified, explain yourself. And depending on your contracting officer there, you may or very likely may not have an opportunity to repair that. So be ready for it, be ready and make sure that you're thinking that through in terms of properly marking. Non-conforming means that you've used a marking that wasn't authorized. So remember I talked about the very strict language in the DFARS that sets out the required terms. Use that. And if it's not conforming, usually you'll get a chance to fix it within a certain period of time, but not always. So make sure you're using the right ones. Because if your CO comes back and says that they have a question about it, and this restrictive marking that you put on is going to create a problem for your government customer, then they get to come to you and say, give us all your documents, show and prove that you were justified in doing this. And if you are unable to do so in a way that is satisfactory to your CO, then they can do a challenge procedure, which as they walk that through, could end up in the end with the CO being empowered to ignore your restrictive legend, which equates to unlimited rights. And again, this happens. I see it happening more and more. So be ready for this. Know your technology, track your technology, mark your technology, and be ready to prove that you are entitled to do so. So let's talk about SBIR. I don't know where we are in time, but we're going to talk through the basics. So IP in SBIR and data rights is basically that intellectual property that's generated under SBI contract. I believe, I'm pretty sure that many of you are SBIR contractors or looking to be SBIR contractors. So what we just talked about, right, in the know it, track it, mark it, and prove it way, it applies here in the SBIR world. There are some differences here and there, but just those fundamentals are going to get you a long way. Like I said, contractors, you own SBIR data. The US government gets a license to it, but that license is restricted. They only get to use it within the US government. That schema that we talked about earlier with restricted rights and limited rights for technical data and computer software, same thing. Those restrictions apply if you're bringing your privately funded technology. Now, not all of you will. Many of you might get into an SBIR contract and you will be starting with a clean slate, and that's okay. Even then, and this is what makes SBIR so great, even though you are using US government funds to develop that SBIR data, unlike the DFARS, where US government funds are used to develop data, the government instantly gets unlimited rights. Under the SBIR, you get a period of protection that limits the government's use and dissemination of that SBIR data for a period of time. Now, I'm being vague about period of time because this is an important change that just happened. We're going to talk about it in just a moment. But you will have an SBIR protection period. And in that period of time, the US government cannot use or disclose it outside the US government. But then, after that limitation period expires, the US government will get either unlimited or government purpose rights. Those government purpose rights will convert to unlimited after a period of time. Now, keep in mind that the US government always has unlimited rights in what's called form, fit, function, and omit data. I don't have time to get into that for you right now, but be aware of those. And if you've got questions around that, we can talk about it during the Q&A if we have time to get there. But like we talked about under the standard DFARS type clause, there are keys for IP data protection under SBIR. Again, identify it in the specific data rights assertions table if that's incorporated into your contract, especially for your privately funded technology. Track your documentation, properly mark it, and be ready to prove it. Be ready to substantiate your data rights position. So here's what we really need to get to for those who are either entering now your SBIR efforts, or if you're already under SBIR contract or in phase 1 or phase 2, anywhere along the lines. Be aware that there is a new policy directive that issued last year. This significantly changes the data rights allocation in for SBIR and STTR if you're there. And for awareness, SBIR and STTR now, they've been combined into the single policy directive. They're treated almost exactly the same. So this policy directive came out May 2nd. It's not going to apply to funding agreements that predate that policy effective date. It really calls into question for those of you who have already entered into an SBIR, phase 1, phase 2, prior to May 2nd. And now, after May 2nd, maybe you're looking at a phase 2 or phase 3, there's going to be a really big question about how do you handle that data. This is something you should talk to your CEO and your government customer about, and how to treat that, how to track it. The principles we talked about are still true. Know what you're bringing, know what you're developing. Be able to track it under those different SBI phrases. Absolutely continue to market, but work with your government customers to make sure there's an awareness of that, because this is going to be something of a hiccup maybe for some on which SBIR policy will apply before May 2nd or after May 2nd, 2019. But there's also a pragmatic aspect to that, because the DoD just recently, March 17th, issued what's called their class deviation for this policy directive. Basically, the interim language that DoD components are going to use when they're entering into SBIR contracts. So, if you're just now working with SBIR contract, take a look. Make sure you have an understanding of whether or not this class deviation language is in your SBIR contract, or if they're relying on the old DFARS clause, and ask questions about it. Eventually, we will have a final DFARS clause, something that's not just a class deviation. That'll be coming out. But as the SBA and industry continue to work through SBIR, STTR matters, there's word of more changes on the horizon. So keep an eye on this. If you are active, you're working a lot with SBIR contracts, keep an eye on this, because there's a lot going on here. And if you have questions, the SBA website has some great tutorials around this. The SBIR.gov also can be a resource. And then, of course, Capital Factory is a great place to go too. So, quick summary of these changes to the SBIR data rights. Again, I put it up here because you will still continue to own all the data that you generate in performance in the SBIR contract. The old policy, it was 4 to 5 years, depending on FAR, DFARS, for SBIR data rights protection period that we talked about, where the government can't use it outside. Under the new policy, it's a finite 20-year period that starts from the date of the SBIR award. No extensions, no rollover that we relied on before. It is flat out from the date of SBIR award, 20 years through those phases. And what they'll say in some of the commentary around that is that it is intended to really motivate SBIR firms to get to the commercialization side of things, really get them to do that within that 20-year window. Now, US government, after the period under the former policy, gets unlimited rights after that protection period. Now, the US government gets government purpose rights after that 20-year period. And then that GPR right will convert to unlimited rights. And as I noted before, always unlimited rights in form, fit, function, and omit data. Now, marking requirements, again, were the same. You know, you've got marking requirements specific to SBIR. Make sure you know what they are. The marking requirements here are also heavily emphasized. GPR is in there. And the nice thing is they now have express language in this new policy that will give you 6 months to correct marking errors, which I think is great. I think that a lot of companies can use that. So I don't think we've got time for OTA. If you've got questions, drop it into the Q&A and we can go there. But I do want to quickly touch on the DoD instruction and make sure that you are aware that we are dealing with kind of a new era in a way of working with DoD components. So last year, October, USDS Ellen Lord issued this DoD instruction 501044. And it's a policy and procedure for acquisition and licensing. It is unique. It is new. It is something we've never seen before. And speaking strictly for myself, personal basis, I like it. I think this shows effort by our DoD customer that they are really, really trying hard to make things work with industry and make things roll with the change in the way of data rights and so on. So know that this DoD instruction applies to every DoD component, everybody who is in DoD agencies. It applies to them, and it applies regardless of the legal instruments. So no matter whether it's DFARS or otherwise, there are a couple of exceptions. So, you know, if you've got questions, we can talk about that. But it applies, it's broad, it's big, and it's a huge change. It does require fair treatment. Now, you'd like to say, well, of course, you'd always hope that doesn't need to be in writing, but it's nice to see. And it also reminds our DoD customers that they can only seek IP deliverables and the license rights that they actually need. They can't just broadly reach for whatever is not relevant to a stated need. So here's a quick summary of the DoD instruction. I've extracted some of the language that is really key for everybody to know, new and experienced government contractors alike. This DoD instructions requires early planning. Now, CEOs or program managers on the DoD, so it's not talking to you guys, this is talking to the DoD components. They are now required to plan early. They are required to develop a robust, that's the word from the instruction, a robust IP strategy that will work their data acquisition strategy all the way from acquisition all the way through sustainment and maintenance. They have to think about it. They have to think about what they need, and they need to articulate it. It also allows IP and data rights to be an evaluation factor. This is new. This is a little controversial, but it's in the instruction. It basically says if you don't give us, well, they flip it around. They say if you give us what we're asking for, then you could perhaps get a boost in your evaluation. It's a clever approach, and we'll probably be hearing more. I won't get into a lot of this on MOSA. That's an important part that you should know, and maybe someday we'll have a longer conversation around that. But be aware that specially negotiated license rights that we talked about earlier, your DoD customer is being encouraged by this instruction to use license negotiation. That means stepping away from those standard DFARS clauses and really working with a contractor or subcontractor to negotiate a balanced data rights thing, something unique. They're supposed to get creative. They're supposed to listen to you, and they're supposed to work through. It also does, however, tell your DoD customer to really challenge when they feel they need to challenge and request validation of data rights assertion. So it brings out, again, those pointers that we talked about earlier. Know your technology, track it, mark it, prove it. So this is the reminder. Hopefully this gives you a little bit more in the way of insight in what I mean by these principles helping you work through the common challenges of working with U.S. government contracts on data rights. Know your technology, track your technology, make sure you can differentiate it from other funding sources, make sure you watch it through the evolution, mark it, critical, and then prove it. An additional key takeaways that I want you to have, reminder, you own your intellectual property that you create. The government customer gets a license. You really should be thinking through your IP and data rights through all phases, right? And if your customer is required to create an IP strategy for their acquisition, you should be thinking about it too. Be ready to walk with them, be ready to negotiate it. And think about these stages of development, right? So for protecting your IP rights, when you're going to encounter it, the development phase, I mentioned really should start there. Doesn't always, but the development phase, track and record. Then program planning, when you're really going to pursue a particular contract. Think about how you're going to work up that IP strategy. Your proposal phase, this is where you're going to identify what's required for you, negotiate where you feel you can, and then identify your data restrictions in the data rights assertions table. And then on delivery, make sure everything is properly marked and update your data rights assertions table when you are allowed to, and that's usually with mods. Remember, you can negotiate, ask for it. And if it's rejected, you lose nothing. But remember, you're empowered to do that. And as always, consult with a lawyer who's knowledgeable in U.S. government country or other resources if you have questions. This is a fast-moving area. It's changing really quickly. It's an exciting area to be in, but it can also be pretty confusing. So thank you for this. I wish you all good luck. I'm happy to answer any questions that you might have. So, Kevin, over to you.
Janna, that was absolutely amazing. And unfortunately, we don't have a lot of questions. I have a few things that I would like to kind of touch back on, but we do have some really positive comments. One comment, unfortunately, no questions, but that's because the information was very well distilled. Thank you for the great info. Line Dance AI wants to know if you offer training in presentation skills because they thought that your presentation was so well done. And specifically on such, you've made a subject with levels of complexity actually understandable. So,
okay, I'm glad to hear that. Really glad to hear that.
So good work on that. And I'm going back and forth to read comments on a screen that's got a delay. So apologize for that. So I liked your takeaways. Definitely, the no mark. There's a couple of other things that I think that would be interesting to highlight from your lecture, or at least things that really stood out to me. One is in product development. I mean, most of our companies, or at least I coach all of our companies that they should be building a commercial product and they should be trying to squeeze money out of the government to do so, and to supplant a funding round or augment a funding round. And that might in some cases affect IP, but they're also building money on the backs of, or they're also building products using investment capital, using in some cases bootstrapped or revenue streams. So they are building products using other people's money than the government. So a really good takeaway is make sure that you are being very meticulous about documenting what the government is paying for and what they're not. Because the government is going to be 100% excluded unless you give away data rights from anything that you developed with your own money. So I love that. Another takeaway is, and this is, given your position as corporate counsel for Northrop Grumman, you may not really be willing to give a straight answer on this question, but acting as a subcontractor, you obviously can enter any contractual agreement you want to with that prime contractor. However, they cannot force you to condition intellectual property rights on being awarded that subcontract. Did I understand that correctly?
You did, and it's not Northrop Grumman specific. I mean, this is a principle that I think is really important for subcontractors to be aware of. You can enter into a separate agreement with Prime or others relating to the IP rights or the license exchange with respect to a sub and a prime. That can be whatever the negotiation requires. But what a prime cannot do is condition the grant of a subcontractor via the prime contract itself on a change or increase or other modification to the license rights, the data rights that the subcontractor is granting to the prime and the U.S. government. So basically, the prime cannot interfere with that license grant between the sub and then ultimately the U.S. government contract.
Okay, so that's good to know. So there is room to the bottom line answer is that you do have the ability to negotiate that. And if a company is hearing from a partner or a potential partner that, since we own the contract, we necessarily own all the intellectual property, that's just patently false.
That's, yeah, that would, yeah, that if you have a prime coming to you saying we own all intellectual property that you create under this subcontractor, that is in direct contradiction with the rules. Right.
Fair enough. So we do actually have a question now from one of our more brilliant startup founders, and then it's a question that I'm not even sure that I can read, much less answer. So, can you comment on the rights of emergent data, such as that, for instance, from a generative adversarial neural network that is used to create data? An example given is NVIDIA facial recognition.
You're going to get into that? Oh my goodness. So this is a challenging area. And in fact, there are some groups that are working right now to figure this out. I mean, essentially, and whoever this individual is, I'm assuming that what you mean by emergent data, we're talking about data that comes out of these neural networks as a result of its processing. We're talking AI, machine learning, and other sort of modeling, right? And so this is data generated by these, let's call it processing by the computers, for those of you who are not tracking that kind of stuff. And the question is, who owns it, right? Now, we end up getting in a lot of conversations with government customers around this, both on the industry side and in just working this through. This is, to use your word, an emergent area. Right now, the position is if it's generated under a U.S. government contract, and that's where the funding is going, then there's perhaps something to say about the U.S. government getting unlimited rights in that. However, if it's generated not in performance or generated under a U.S. government contract, then there's maybe a question mark. And I strongly encourage people to work with your counterparts on the government side, or your prime if you're a subcontractor, and figure out what the data rights allocation can be. This is one of those areas that's perfectly designed for specially negotiated license rights, but be ready to articulate it. Be ready to articulate what rights you think you need in order to retain control, and make sure that those rights are still going to enable your government customer to pursue whatever their mission goals are as well.
So that's interesting. I hadn't even thought about it, but yeah, I mean, if you're automating the process of writing code, then what are the data rights associated with the code? Just as one example. So that's interesting. I do have one additional question, something that stood out for me, which is, there's this DoD policy you mentioned that's relatively new, relating to that they're not authorized to attempt to negotiate data rights that unless they're necessary for the government to consume, integrate, maintain the life cycle of the product. Those are kind of typically the justifications that you hear. So assuming there are probably some assertions that are made in conjunction with that, and I also like to assume that people are not going to always follow the rules, or that there could be some differences of opinion. So are there any remedies for a company who wants to, quite frankly, enter into a contract, but believes that they're being asked to give away rights that are not necessary? Are there any ways to second guess those assertions, or those representations, or those license parameters, such as an appeal to the GAO or something after the fact?
Yeah, there are, and those sorts of actions, whether it's before the GAO or the Court of Federal Claims, those happen. I mean, there's litigation around that. I won't say a lot, but it happens. I think that a lot of companies are sometimes strategic in their choice and how they parse that. Many companies, I believe, will rely on negotiation rather than an outright litigation. I mean, really, you're suing your customer. Right. So for it to get to that level, there really needs to be a strategic purpose behind that. But yes, it happens. And I'm not going to say it happens deliberately on the part of the government customer. It really is a legitimate need sometimes for them. So ask those questions. With that DoD instruction that I mentioned, the government customers, the COs and the PMs, they are being asked to talk to industry, talk to them, and make sure that there's an understanding of what that contract structure and scope is going to be as the parties work together and work towards a final contract. So use those opportunities to get clarity and to work through the data rights allocation of that before it ever gets to the point where there's going to be some sort of dispute. That's expensive, it's hard, it's time consuming, and if it makes sense to avoid it, see if that's even the first option.
Excellent. Well, Janna, thank you so much. This has been
My
thoroughly
pleasure.
informative, very well presented, and I know that our audience is going to get a ton of value out of this.
All right.
So thank you, Janna. And now we're going to go on a break for about, let's say, about 8 minutes. We'll start at about 12:42. Give folks an opportunity to take a break from the screen for a little bit, and we will proceed with Heather Richman. And good afternoon. Welcome back to our second session of this final day of Defense Academy. I'm super excited to hear from Heather Richman, although I am a little bit sad that this is the last block that we're going to be delivering in this Defense Academy. Thank you all for participating so far. So I'm going to introduce Heather Richman now.
Guys, I'm having a bit of a hang on there.
We can see you. It's
okay,
fine.
Perfect. Hi guys.
Now I have a cat over my shoulder again.
So
Heather is a well-known player in national security technology and investor circles. She's been involved in delivering technology and innovation solutions to government customers for more than a decade with big companies like Cisco, and she's currently an entrepreneur in residence at BM&T Partners, which provides a platform where innovators can work together at the intersection between business, government, academia, and society. BM&T also created the Hacking for Defense program, which is a university-sponsored class starting at Stanford University that allows students to develop a deep understanding of problems and the needs of government sponsors in the Department of Defense and the intelligence community. And I believe Hack4D is at 40 campuses now and headed to 50 by the end of the year or something like that. Is that right?
That's correct. You got it.
Yeah, and so most importantly, she recently founded the Defense Investor Network, which is an informal group of U.S. investors who are tracking dual-use technologies of interest to the Department of Defense. And even more important than that, she's here today to talk to you about the impact of foreign investment, foreign ownership, influence, control, board seats, and any other kinds of issues like that that could potentially cause problems for your companies if you want to do business with the DoD. So with that, Heather, thank you so much for joining us, and I'm going to let you take it away.
You got it. Hi guys. My name's Heather Richman. I'm based here in Palo Alto, California. I've got fires about 9 miles from me, so we've got a nice overcast glow here. But keep Northern California in your thoughts, please. And actually, one of the founders of Hacking for Defense, Steve Blank, he actually lives out in Pescadero, which is on fire right now. So it's kind of top of mind for us out here. But thank you, Kevin. I, to be honest, I hate slide decks. I hate slides. I'm terrible at making them. So I thought I would just introduce myself a little bit first, and then we can jump into the slides, which I'll make full screen in a second. But I can't see you guys when I have it full screen. So just briefly, I spent about 5 years in Washington, D.C., back doing defense appropriations. This is back in 99 to 2004. I was working for Senator Schumer from New York. Obviously, in the middle of that time frame was when 9/11 happened. And so helped kind of with the redevelopment of Lower Manhattan and managing that funding, and then helped set up DHS, Department of Homeland Security, from a funding standpoint. So that's where my mission focus comes from. And I use that term, mission focus. One, I really want to thank all of the entrepreneurs out there. I was a founder of an electric motor company. I know what it takes. It's hard as hell. We really need you. We really need entrepreneurs right now, and those that are national security minded and national security focused. I personally appreciate your mission focus. And I know that it sounds a little cheesy saying all this, but the reality is what you're doing and kind of who our adversaries are right now and how fast they're moving. We need your skill sets. We need your technology. We need your know-how, and we need you to not give up. So a lot of the things we're going to talk about today and a lot of the tools and networks that I build out are because I've been inside and I work with folks that have been inside, and it's hard. And when I say inside, I mean inside the Department of Defense. There's a lot of things that they need to change as well, and they know that. But it's a very, very large aircraft carrier that they have to turn around. And so stepping outside of that with BM&T, and I'll tell you a little bit about that. And then some of the work on trusted capital and these other things that we're doing are to basically almost build, an ecosystem and a network of entrepreneurs that are mission focused outside of the DoD. Obviously collaborating with the DoD, but there's a lot of work that can be done and needs to be done outside. So just really thank you all for doing what you're doing. I know it's difficult. I know it's even more difficult during COVID, doing this remotely. I wish I could see your faces, but don't give up ever. And I guess that kind of goes into, I fast forward a little bit. I actually came back out here. I'm from California, came back out, ran government relations at Stanford for a number of years. And during that time, really started to dig into the investor community here in Silicon Valley, and tried to understand, what makes investors tick and why they do what they do. Obviously, there's some that do it to get really rich, but there's a lot that do it for other, for mission focus in various areas. And so I always found there were kind of two buckets of investors for me. And the first bucket were those when I would sit down, and obviously it's 2005, so 9/11 was still very much part of my day and my life, and would come in, and there were those investors that would tell me that Silicon Valley and broader innovation community was built on DoD funding and DoD innovation, and there were those that I had to tell it to. And so I kind of just filed that away and kind of kept in mind which were those investors that have mission focus and that see the world, the way that many of us do. And so it's critical, right now the private capital, as we call it, the private capital folks, the private equity folks, distressed debt, venture, all of it included. The face of war is changing, and the way that we're going to have to combat it is changing. And so this isn't, send a bunch of people to the desert anymore. This is, urban warfare, biological warfare, cyber warfare, you name it. And so, the investment community is starting to understand that they need to be part of that. And they, I think for many, many years, the sentiment, or at least the belief that the sentiment here in Silicon Valley was that, investors didn't want their companies working in the defense sector or working with the Department of Defense for a lot of reasons. It's slow, it's unpredictable, you can't count on it from one year to the other. It's slow. And so I think that's changing. And part of the reason I started something called the Defense Investor Network was really to bring together those investors that I knew were in that bucket that had mission focus, and to start having those conversations and to really understand, one, that they weren't alone, that there's a lot of investors that feel this way. And so you guys are coming into this space at a time where there is a bit of a tipping point going on with investors. As Kevin mentioned, it's not a thing. It's not an official group. We get together. I jokingly call us ladies who lunch, but it's me and about 7 to 8 dudes and Eileen from Incutel. But the idea is that we get together and talk about deal flow, and we talk about companies that we're seeing, and we're talking about entrepreneurs that we're seeing and those that are mission critical. And so we're not, it's not kind of a policy group or a speaker series. It really is getting down and saying, what are you seeing? What sorts of deals are you seeing? Just a bit of an example of some of the members. Again, we don't publish any of this. We don't have a website. We don't have a newsletter. But Incutel was a key part of this from the beginning. Lockheed, but then you've got Greylock, Bessemer, Andreessen Horowitz, General Catalyst, Lux Capital, those sorts of, so some really big names, but there's really dedicated, managing directors and GPs in each of those funds that do understand why you're doing what you're doing and that you need capital to do it. And so, happy to answer lots of questions as this goes on. And I will quickly run through, as I kind of started it, I don't like slides, but I also really believe in giving you guys actionable information, not just kind of talking at 30,000 foot level. And so where I can, I provide email addresses to things and links and all that kind of stuff. So, and any questions that you have, I'll do my best to answer. I'm a very transparent person, and I want to make sure that you guys get the information that you need. So I'll go ahead and run through these slides. I'm terrible. They're text heavy. Don't worry about it. We'll answer some questions, get you guys some good information. But I call it keeping it clean. Basically, and I'll full screen it. I know I'm making Brian crazy right now. But basically, where your funding comes from is a matter of national security. So as you are thinking about raising dollars and getting approached by different funds and getting approached by even potentially different high net worth individuals, where they come from really does matter. There's a list here that is actually part of the CFIUS team, and I'll get into that a little bit. But there's a longer list than you think of countries that are problematic to us. Obviously, if there's some of the obvious ones: China, Russia, Iran, North Korea. But there are far more. So I will run through this. I will try not to bore you. I will, not read the screen completely, but give you some backstory on a few of the things here. But any questions you have, I really encourage them. So I'll kick this into full screen and we'll get moving here. Okay, so that's me. Actually, I don't have my email address up there, so I'll go ahead and give that to you. It's just hrichman@bmnt.com. Perfect. So I'll move forward. Okay, so CFIUS, I have no idea how familiar any of you guys are with this. CFIUS is a set of regulations, and that stands for the Committee on Foreign Investment in the U.S. CFIUS is actually led at Treasury. So the Treasury Department leads it, and many, if not most of the agencies then have kind of a lead. I've been most involved with the DoD team, although Tom Fetto, who's the Assistant Secretary for Investment Security, really awesome guy. If you have questions, I'm happy to get you in touch with his office. But he is really trying to think through, the regulations that are going to be being put onto companies and on investors alike. And so whether that's, having, I'm just going to pick on China for a minute, but having, Chinese investors in your fund, or whether you're a company and you have a Chinese investor on your cap table or even on your board. And so these are obviously challenging things. And so Treasury is kind of leading the formation of the regulations. He did actually come in and speak to our investor network last month, actually in July. and was incredibly forthcoming, wants to be educating folks on this. And I think really I guess the sentiment I hope you'll take away from this is that this isn't government trying to be overarching and looming and make your life more difficult. It really is national security affected. It really is important. And so as I talk to the investors quite a bit, investors are really good at finding loopholes and ways around things. And I said, guys, this isn't the time to do that. Like, this is the time that we need to come together and actually set up a set of regulations that work for everybody. And so as CFIUS regulations are coming out, we're doing as much as we can to get a hold of them and actually get investors and companies get their feedback on the regulations before they're put out there, because we know how difficult your life is already. And then to actually, slap a bunch of regulations on top of that is challenging. So it's not always so transparent, but I hope that you'll understand the spirit of it is actually to protect our country and to make sure that if there is foreign investment into a company already, we can help unwind some of that. And if you're raising capital now and moving forward with that, or raising a fund, if you're an investor, that you're being very cognizant of where that money is coming from. And even if somebody wants to write you, a $40 million check with really great terms, you're going to put your Patriot hat on and say no, thank you. So the DoD CFIUS team is housed under Secretary Ellen Lord. The DoD CFIUS lead is Andrew Pahutsky, and he's a brand new CFIUS lead, actually, and I'll get into who it was and where he went. And then the Deputy Assistant Secretary for Industrial Policy is Jeb Nadner. He's also brand new, is Jen Santos until just recently, and she moved over to do some important work over at Navy. So critical to the Defense Industrial Base, that's why we're all here. Again, Defense Industrial Policy Office, which is under Ellen Lord, is really this place that they wake up every day thinking about the Defense Industrial Base, thinking about supply chain, thinking about, I think the COVID pandemic has really highlighted the fact that I think we need to be manufacturing and making stuff in the United States, and we need to repatriate a lot of that, securitize it, modernize it. But there's a lot more than that to the industrial base. And so I've actually just started calling it the Defense Innovation Base because it sounds a little less archaic. But that, you guys are all potentially, part of that. And once you start working with, various branches and COCOMs, that you become part of that. So this is just very kind of a quick overview. Trusted Capital brings corporate suppliers that are critical to the defense industrial base together with trusted capital providers. That's the goal. We can get into where that is in a minute. Major risk from adversarial capital to innovation and supply chain integrity. I really want to say that 10 times. I cannot emphasize enough how when capital, again, from foreign sources, and then obviously when IP is exposed, we call them information rights in the investor community. So when you put money into a company, you have certain rights as far as the information that you're allowed to, that you're privy to. And so having, your company's information, your intellectual property, your trade secrets, depending on how secure those are, and sort of the information rights or the visibility that those with adversarial capital could have. Also, there are those that are just trying to straight out buy either teams, folks like yourself, or intellectual property. And so who controls that IP and who controls those teams too is absolutely a matter of national security. So you can read the rest of that there. Basically, it goes through a little bit about the screening. There hasn't been a lot of transparency around TCM, and we're going to get into that in a second. So I'm hopeful that I can answer some questions and demystify some of that for you. So Trusted Capital, it was actually called Trusted Capital Marketplace for a long time in the second line there. I've kind of backed up and really want people to start thinking about it as Trusted Capital. A marketplace is one piece of it. At the very bottom there, I talk about, in partnership with SOCOM, that Trusted Capital is launching a scalable platform for rapid partnering. But Trusted Capital as a whole is much more than that. There's a lot of work going on with IDFC, which is the new name for OPIC, which is basically a bank. They're calling it the DFC. They're kind of taking the focus off of the international component of that, because what we're seeing is a lot of actually kind of infiltration into the domestic markets. And so we're looking at it more domestically. But DFC is actually partnering with and now has an agreement with DPA Title III, which is a presidential authority. DPA Title III is something that the presidents can enact and say in the time of war, which whether or not you want to call it that, war or that they basically, if industry isn't meeting the needs, they can go in and provide some capital, provide some resources. I won't say break some rules, but be a little more lenient on certain things than they normally And so all of this is kind of part of trusted capital. There are a couple of companies right now that are going through bankruptcy that have spectrum that's really, really important to us. One's called OneWeb. And so the idea of going in there and potentially using distressed debt or other sorts of financing tools is all part of trusted capital. And so I think the marketplace is I think what's probably most interesting to startups, just because it is, if we're asking or regulating that you can't take certain types of money, the goal is to provide a platform, to provide an ecosystem where of clean capital is what we'll call it. And so just money that, we vetted it, we know where we meaning trusted capital. I'm sort of part of that sometimes. But also I do a lot of that vetting out here in the private sector as well, just to make sure that, as we're having these conversations with the Tom Feddos of the world and the Honda Grits of the world and the Will Ropers of the world, that they know that they can trust, who's in the room and talk openly about the challenges that we're facing and what's the capabilities that we need investing in. That's supported by a group called the U Group. That's their email right there, trustedcapitalinfo@U Group. I highly recommend they hear from you. I'm kind of out here. I'm very externally facing, obviously, but the more companies they hear from asking questions, I ask them questions all day long. They get very tired of me asking questions, clarifying questions, usually coming from investors. But on the company side, feel free to use that. If you're not getting a response, please let me know. And we can get you in touch with some folks over there. So I just didn't vet with them ahead of time that I could put their emails up on a PowerPoint, so I decided not to, but happy to help with that, and I can pass that information along to Kevin and Brian as well. Trusted Capital Events, we'll actually get into that on the next slide, but they're partnering with the services and with the combatant commands, and so they're doing, they've done Army, obviously with AFC, they've done an event with SOCOM they just did, and so I guess the events has been a way to kind of get the word out a little bit. They're going through a little bit of heartburn on some of that right now. Obviously, it's a bit challenging with COVID. But their first event was actually, the kickoff was last November. That was an in-person event. They did one more, I think, in-person event early 2020, and then it's been online ever since. And so just between you and me and everybody online, there's been a bit of a challenge getting the word out sometimes. Just since I've been involved, I was actually working with Ellen Lord and a gentleman by the name of Dave Stapleton, who I'll get into in a second, since last January on this marketplace concept and kind of this trusted capital concept. And so since then, now they're on their third DASD. So there's been a lot of turnover, which is challenging. I think actually one of the biggest challenges between the public and the private sector working together is the amount of turnover inside the building, inside the Pentagon. And so there have been three DASDs, and up there at top, the new TCM lead is Katie Arrington. She's fantastic. She actually comes from the private sector. I'm really excited. She's probably about 2 months into her job. So still kind of on the uptick there, but I'm really excited that she's at the helm of it. And I have a feeling we're going to see a lot more transparency and a lot more kind of, outbound information, I'm hoping. There is kind of a methodology that they're doing, investor vetting and company vetting. I do have the decks for both of those, and it's not a deck, it's actually a PDF that I can absolutely get out to you guys through Capital Factory, just so you get a sense of what that looks like. And then Dave, I put it twice. That's basically where you send your completed application. You send it into Dave, and he's really fantastic. And so he's over actually part of DCSA. The next one, the Defense Counterintelligence and Security Agency. The other one's doing all the vetting. And so actually Dave Stapleton, who used to be the DASD, who used to run CFIUS and TCM over for DoD under Ellen Lord, is now over at DCSA and doing yeoman's work, like really doing a lot to get this vetting up and running and far more efficient, because it has not been. And so the idea is to really build out, the companies that have been vetted, the investors have been vetted, and get these things moving. Currently, the ecosystem has about 100 capability providers or companies. And then they got the processing about another 40 and about 12 capital providers. And that's been one of the biggest challenges is on the investor side. So that's something that I've been brought on to help with. Areas of focus. So when we talk about CFIUS and then kind of the areas that Trusted Capital will be really looking at, here you go. So healthcare, biomedical, unmanned aerial systems and drones, which is a super top of mind. Actually, that and 5G are probably the most top of mind. AI is right behind it. They're all ridiculously important. Artificial intelligence, obviously, space, cyber, robotics, semiconductors, microelectronics, huge one. That's one that we're looking at quite a bit about kind of that repatriation and securitization of manufacturing here in the United States. So that's a big one. Quantum, autonomy, hypersonics, directed energy, nuclear, castings and forgings, and rare earths. Trusted Capital is working on the following collaborations. So at the bottom there, I've got the link. You can just literally Google Trusted Capital and it pops up. But then there's an event click. As of right now, the website does not have any of these on it. The last one they just had a few days ago was the SOCOM AI event. I think that's on there, but I think that's the most recent. So it looks like they might be doing an event with the JAKE, likely in September. The JAKE is the Joint AI Center, so focusing on AI again. There's going to be quite a few events, I think, focusing on various applications of AI. JADIF Venture Day, focused on therapeutics and testing for COVID. I don't have any sort of inkling on a date. I just know they're thinking about doing an event around that. Trusted Capital Venture Day. Like I said, I talked about DFC or IDFC a little bit ago, DFC. And so that would be kind of in conjunction with that, I think, to educate folks around kind of what that can look like. R&E Venture Day focused on hypersonics and microelectronics. And then actually Trusted Capital has gone out and asked the large prime contractors to give a list of critical suppliers to explore vulnerabilities. So it's a lot of supply chain securitization. They're looking at quite a bit of that. And then back to the focus areas, those are kind of the main ones. But I mean, as far as the events, we've talked a little bit about them being a little bit more outwardly facing with those and figuring out some sort of listserv or email chain to get on. As of right now, I don't believe that exists. But if we do find that out, I'll make sure that we get that information over to you guys. I guess finally, I'll just end on this. I get a lot of questions around global allies, foreign founders, that sort of thing. We love you. We love foreign founders. I've actually been in a number of conversations and participated in a number of roundtables with NATO. NATO's looking at, how do we do this, with our trusted and our allied countries, and how do we kind of create an allied trusted capital program? Because if the United States is doing this, but none of our trusted allies are doing this, it doesn't matter. And so how do we start looking at that? So we're already doing work with the UK and Australia quite frequently, but now NATO is really jumping in and saying, what would this look like on a global scale? And so as obviously, if we're looking globally for capital, we're also looking globally for talent and for companies and that sort of thing. So I think you're going to be seeing a lot more willingness, potentially even with regard to the cyber programs and some of the programs that in the past have not provided funding and provided opportunities for foreign founders. I think you're going to see some of that changing. I don't have many specifics on that at this point, but I know for a fact that we're looking globally. I think the face of war is changing, and this is global. And so it no longer, COVID's a very good example on how this affects, the entire planet. So a little less US centric. And so we actually we had our second or third, I guess, meeting with the NATO group. And then Lord actually came out and talked about kind of this global trusted capital, concept, pretty much right after that. So I'm really excited that she's really biting into that and taking hold of it. So I think that's my last, there we go. That's it. So let me escape out of here and open up for questions.
Well, Heather, that was awesome. We are down to about 25 entrepreneurs. We don't have a whole lot of questions coming through the chat. I have a couple of questions, just a couple of things that I would like to either address, if not already addressed, or to highlight. So is there like a general number in terms of percent ownership that a company should be looking at if they're interested in going after? And I'm also going to break it up into different programs. Like, does the government look at, foreign dollars or the percentage of ownership of foreign money, or the percentage of foreign money in your company differently, depending on whether you're going to go after like an ITAR or a weapons master list technology, or you're just going to go after a program like an SBIR or an OTA or something like that?
Right now, yes, of course. And I think, and I hate putting all foreign investment in the same bucket, because it's very, very different. It's very country specific. So at this point, like I said before, we're just going to say it. If you've got Chinese, investors in there, you're going to have a much harder time. As of right now, they haven't been very effective on vetting those. So as far as SIBRs go, I'm not sure they are actually vetting. I know that's changing. I know that they've actually gone through kind of a phase 1, phase 2, and actually a company was getting vetted to go down the pathway of a phase 3, and they realized that they had some questionable funding in there, and so they had to yank that. And so they've gotten to the point where before they're like, oh, if it's small, it's not really a big deal. It'll kind of shake itself out. But the problem is, once you do get further down the line, you've basically wasted a phase 1 and a phase 2, not to mention everyone's time. If down the line, that technology or capability can't be used more broadly. And so they're trying to get smarter on it. They're trying to be faster with it. They know that it's hard on the companies. It's hard on, so that's, they literally have an entire office over at DCSA now looking at how to streamline this. how to make it faster, better. And actually, I just heard from Dave this morning through an email, but we were asking before, because before it's been basically until you go through the CFIUS process, or you're kind of earmarked, CFIUS relevant or CFIUS, you're tagged. And then you go through the process. We were saying, I was actually talking to another investor over at MIT, and I said, can't we screen ahead of time? So we're not wasting it. We're not waiting until we get to the end. Can we just start to screen some of these companies ahead of time so that we're not then putting our dollars in knowing that, either the founder or whomever, they were actually talking about vetting companies at this point, but on the investor side too. And so that hasn't been possible. They're like, no, you just have to wait until you're actually officially dog-eared, CFIUS, questionable, and then we'll take you through that process. I just heard that they're working on that very diligently, and he assures that we're going to have a process in 5 months. So we're going to see if we can get that closer to 3 months.
Oh, awesome. So yeah, I mean, most of the companies, and I don't want to overgeneralize, but we have to generate kind of these programs to hit the center of mass of the companies that we're looking at. And most of our companies find SBIR being a great entry point, particularly the AFX open topic SBIR, because it's open. You tell them what the topic is rather than the other way around. It's accessible. It's an easy application process. I know that in that application process, they now are requiring companies to disclose foreign investors and any foreign individuals that are going to be working on the project that are obviously known at the time that the proposal is submitted. Yeah. I don't know whether or not that actually influences award decisions. Outside of, do you meet the criteria of domestic ownership and domestic work that are stated in the SBIR proposal or the solicitation rules? But the information is there.
Yeah, it's been interesting because we've had, some folks, Linda Laurie, who's Ellen Laura's general counsel, has, talked to our group quite a bit and about, and I'm going to talk about from the investor side just for a minute, just because that's where I've been talking about. But basically, like, can you have Chinese LPs in your fund? What, how, if they don't have information rights, if they don't have visibility into the company, into the IP, is that okay? It was kind of, they're trying to kind of, carve it out a little bit. And basically the answers were, don't. She literally, she said, just don't. And I know that's, there's so much to unwind later, and we really don't understand. Something else that came out actually when Stapleton and Linda were here last March, I brought them out here during RSA. We just had a bunch of, conversations with investors, but then actually a lot of the investors were saying that a lot of the IP leakage, which is something that we're very concerned about, is actually happening at the university PhD level. And so, we've got a lot of students that are then, coming here to get educated and then going back and basically stealing the IP. But so there's lots of different schools of thought on investors and if it's and again, I'll just pick on the Chinese, I apologize, but if it's a Chinese investor that's in, a reputable fund, and, the fund, the board member is one of the general partners who's American, and, or is that okay? Is that going to work out? And there's so many ways to thread that needle. But honestly, like the world that we're living in right now, and we'll be living in for a very long time, there's going to have to be a brick wall. Like, we're going to have to shut this down in an aggressive way, and we're going to have to shut off the fire hose and start to try to unwind some of it. There's no way we're ever going to do all of it. You've got funds, you've got large investment funds. SoftBank's a great example. Everyone thought they were Japanese. They're not. They're mostly Chinese money. And so, they're very good at hiding it. But I think we're pretty much going to have to just take a gut check and figure out, stop taking Chinese money, stop taking Russian money. And it's hard. And the thing is that companies, and actually some of the investors I've spoken to, they, to be kind of part of our network, I said, I've kind of gotten a little bit of underground word that there might be some Chinese money in your fund. Can you check that out? And some of them don't even feel comfortable having the conversations with their general partners. Like, it's a very uncomfortable topic for people, and you almost don't want to know, because you don't want to have to go find a new job if you don't agree with, with your. I've actually had this conversation with somebody who's a veteran, really good guy, amazing, heart of gold, wants to do all the right things. And I said, well, I need you to kind of go and, find out if this is true. They have a Hong Kong office, and there's been some challenges there recently with China kind of coming back in and taking more power over Hong Kong. And I said, if you've got a Hong Kong office, to me, that leads me to believe that that you could very easily, have some breaches. And so that's just something that we need to look at. And he goes, yeah, but if I go and ask, then, what if they say yes, and then I have to find a new job? I'm like, or you could knowingly keep working for, a fund with Chinese money in it, which again, everyone, on their own, but I think we need to be really honest about it. And it's hard. It's really hard. And it's really hard when you're a founder, especially doing any sort of hardware, and they write bigger checks with good terms. And so I get it. I hear you. And so that is 100% the reason, that this idea of trusted capital, bringing together a network of investors that we say, hey, come talk to these folks. These are folks that are vetted in there, and working with Katie and with the TCM team to really make that pool as robust as we can is, top of mind for me every day.
Yeah, that's interesting. So you may or may not know this. I'm a lawyer by background, although I don't practice anymore. And one of the areas that I've worked in is in conflicts of interest between various aspects of government contracting. And, the term of art that we use is a Chinese wall. So what you're describing literally is you need to build a Chinese wall. And on the other side of the wall, there's no Chinese money, right? Because that certainly would be easier than trying to interrogate the terms of any individual term sheet to find out what rights that investment's going to carry, right? Is it carrying a board seat? How many board seats? Is it carrying, some flowback of information or IP or anything like that? So, so that's a good one. So a couple of questions in the chat relating to like the source of money. And you mentioned that not all foreign money is the same. Yeah. And in the industry, or I should say in the defense community, there's this concept of Five Eyes. And I think it's related really to how we share classified information. But these are countries that are our friends. It's the UK, it's Canada, it's Australia. So are those countries, 100% safe? And that's where I think it gets a little bit confusing because, like the SBIR program, again, being a program that a lot of our companies use, 50% foreign ownership is an absolute barrier. And it doesn't matter who that foreign partner is. If it's 49%, or if it's 51%, you're out. Even if it's a Canada-owned investment firm.
Yeah, we've been talking about a bunch of that. We've also been talking about, there was also the rule that if you're 51% venture-backed, you couldn't apply for an SBIR.
Maybe, depending on how many... You gotta do a lot of more due diligence information. That's really hard, but yeah.
And so that, and actually we, Hondo actually came through and the Secretary of the Navy wrote a letter to the Small Business Administration back in May, basically saying it was kind of COVID responsive, I guess, but this basically saying we're not going to listen to that. Like if there's a company that, is 60 or 70% venture owned that we need to work with, we're just going to work with them. So that's changing. The Five Eyes stuff, that's changing. I mean, there's still the same. The challenge is, I think, is
on the percentage of ownership in SBIR, it becomes an issue of how big is the company,
right?
And so I think they still have to do some analysis, and it's going to depend on the composition of the funds that are invested in them. Absolutely. And a bunch of other stuff, and a bunch of lawyers writing memorandums expressing like what does this mean? Are they in the company or not?
And I think the challenge on the foreign investment piece, even if it was a Five Eyes, is that we just don't have the authority to have oversight and to dig into that fund. So it's we're kind of taking their word for it, and that's I think where some of the challenge comes from is we don't have that transparency. If it's a U.S. if it's a U.S. fund, we can dig in and figure out where that money's coming from a little bit with a little bit more authority, I guess, if you will. But we're doing a lot. I mean, space, I think, is one area where it's becoming, amazingly clear that, UK is doing a ton on space and they've got some amazing investors over there. The European Space Agency, the UK Space Agency, also their way of investing, their public and private overlap on investing is very different than ours. And so, we're bigger. We've had, kind of stricter rules, but like, it's going to be really interesting to see what happens. I think the overall integration of these two worlds is going to be happening at a much more rapid pace. And I think that's a good thing. I think that, the venture community, the startup community, we need to the flow of information and communication between the Department of Defense and the IC needs to be much, much more robust. We need to know what the other's doing all the time, because the talent that you guys are representing right now on this call, like that's the talent that's going to, that's creating the new technologies that's going to keep us, ahead of the game. And so, number one, thank you again for what you guys are doing. And for you, startup founders, like it's hard work. So, I guess the concept of TCM and all this is to keep it safe, but, is to hopefully help you guys have a little bit of an easier time.
Yeah. I like I think you would agree that the trusted capital, really, it's not a thing. It's a concept, right? It's the concept of, keeping your cap table clean from foreign investors and specifically clean from certain types of foreign investors. But in that vein, I think that touches one of the questions, which is a question of when should companies start interacting with the trusted capital community? And I think the answer is are you raising money or not, right?
Yeah.
Are you raising money? Because if you're raising money, then you should be looking at trusted capital as a source, or you should be looking at the source of the capital and determining whether that's going to impact your chances down the road. But you also mentioned like some of these trusted capital venture days.
Yeah.
Are those good opportunities for companies to participate in?
That's a great question. Like I said, the program has had a few starts and stops, and so I know that there've been it's getting there. It's getting there, and I know that they're again. I think part of it's been the communication outbound. It's a little challenging too, and something else they're struggling with is the whole idea again was if you're CFIUS relevant or CFIUS, you kind of you're gonna get tagged CFIUS relevant critical capability. The idea that those companies that have that designation should be kind of put in front of trusted capital. If you're on that, focus area list and you're working in something that is right in the list, which is like everybody these days, definitely, start getting involved. Like, please, it's usually, the events are virtual right now. Before you actually had to like fly to the center of Texas, which isn't too far for you guys, but for me, it's a long way. And so I think the fact that you can do it virtually, take advantage of that, start to understand the program. Again, I kind of encouraged you guys before during that, where there's that trusted capital info, just start getting information. They need feedback from the end user, which is you guys. And they're not asking for it. So I'm asking for them to start feedback and to start, pinging in and letting them know you're there. And
let me give you some feedback. The application process is nearly impossible. It's terrible. I have actually filled out an application as an investor that got no response because they opened the applications about 6 or 7 days before the drone.
Before, yeah.
Oh, is that what it was? Yeah, I remember it was right before the drone venture day at Texas A&M, which is the one that you're describing. The application process was super hard. It requires you to disclose a whole bunch of things about your fund that I don't necessarily think are relevant. Like, what are the nationalities of all the companies that your fund has ever invested in? Yeah. So Capital Factory has equity in 600 companies. That's a lot.
Did it ruin
right? And no, we just left it blank, which is probably why it was never acted upon, because it's like, why does it even matter if you know my LPs are all domestic? Why does it matter because we don't try, we as a rule, we only invest in US based companies, but we don't do due diligence on that. You know what I'm saying? We look at formation documents. We don't trace IP back to some, foreign, subsidiary or anything like that. Like we just don't.
Yeah, no, and I'm glad you said it instead of me, because I'm trying to be honest and open, but a little diplomatic. So yeah, it was terrible. And since then, that was kind of the information in the black box. I got kicked out of it 3 times, and I was going through it just so that I could then report to the investors what they were up against, kind of to come prepared, because an investor they're busy and they get kicked the first time, they're like, forget this, and so that's happened, and so we're trying to streamline some of that. But the new one is actually kind of more of a PDF. You fill it out, you send it in. But I'll be honest, I've heard from a lot of investors too that they still don't get a response back. And so, like I said, none of this has been under Katie's watch. Katie is brand new here, and I was really bullish on making this a better process. There was actually a TCM day that was scheduled about a month ago, like right before she came, right after she came on board, and she canceled it. She goes, I just don't feel good. Like, this isn't good enough. This isn't right. And so she's very cognizant of that. And that's, we're, like I said, the more feedback she gets, the team gets, like, please give feedback, even constructive feedback. That's the most important kind of feedback. I super encourage you, and I'm happy to provide you, with some additional contact information too for the team, but they need to be hearing this. They hear it from me ad nauseum, but I'm one person. And so, we need. Well,
Dave, I've traded some emails with Dave Stapleton. I've traded some emails with Katie Arrington. They're both great people. Absolutely. So Andrew, to answer your question, if you're raising, you don't need the trusted capital marketplace. You don't need investors that are vetted by this specific process, but you should know the source of the money that's going into your company. And the TCM Venture Days as specific events, I personally am on the fence on the utility of those events. The application process is hard. It's hard to get in. You don't necessarily need to be there to find the companies that are going to invest in your tech, and they should be. Anybody that's investing in your technology, I think you'd be much better served finding a strategic investor, somebody that's actually going to help you connect with customers, and just do the due diligence on the source of the funds. But as a concept, this is going to evolve, and it's going to get great. So you mentioned CFIUS list. So I don't know if this was on the chart charts that you presented back there. Okay. Is there a link in there or something to a place where a company can say, hey, am I a technology that's going to get extra scrutiny at some point in the life cycle of my relationship with the DoD? Like, how does a company answer that question? That's a very simple concept that they really need to know.
Yeah, well, so this is actually my country list. So if you have money coming from any of these countries, that's it, and I've got a link to that somewhere. That was like buried in the bottom of an email one time. But as far as you're talking about the tech focus areas, the technology areas? Yeah, so that's on the slide there, and you guys can have that, and we can put that out to you. But it's also just, if you literally Google trusted capital technology focus areas, I think that's literally what I did. And an article from Breaking Defense comes up and goes through. So yeah, I mean, if you're in any of those areas and you're doing anything, I mean, they're being very specific about specific areas. Obviously, the AI is very, very, very broad, right? Quantum, these are very broad topics. But there's a lot here that national security. I mean, I won't use the term dual use, but so many of these are now dual use. Like, so many of these are now critical to what we're trying to build. How we're trying to modernize our military. And so it's broad. I mean, anybody who's even listening right now, you're in. Like, just know it. If you're Capital Factory, my guess is that you've got you're at least national security relevant, if not national security critical. And both of those, I mean, there really needs to be just a mind shift. This is and I know doing diligence on an investor as a startup company is difficult, if not impossible. So again, I think that's part of what TCM is trying to be. If you're a company and you're really stuck, email me. Like, we'll help you figure it out. I don't even do that, but I'm happy to help you do it.
Awesome. Well, that's a fantastic offer, and Heather's slides and email will be attached in the email that goes out at the end of this day to the folks who are registered attendees. So if you're not a registered attendee and you're just lurking, throw your email in the chat, and Brian will make sure you get included in that. So Bill makes a really good comment that essentially, the atom bomb, which ended World War II in the Pacific, wouldn't have happened under some of these rules that we're talking about right now. And that actually brings me to a different category, which is, in universities specifically, and there's been some comments about the foreign nationality of folks at various universities and the tech export of or export of intellectual property through universities. But a lot of the early stage, basic and applied level research is happening inside universities. Mm-hmm. A lot of those people are spinning out into companies, and some of the rules around directors and developers is what I like to call it, right? Which has to do with the influence of your company, or the influence and ownership, or influence and control of your company, and who's working on your products. Having hard and strict rules seems to be a little bit limiting. So are you seeing in your conversations any movement on that as well?
It's funny. When you talk on the investor side, we talk to investors, it's kind of a joke around here. They're like, we won't invest in a company that doesn't have Chinese developers. I mean, they'll say it, and we're like, great. Because the talent's real, right? And that's a really hard piece of this. And so I haven't seen, the conversations are happening. People are talking about it now. I guess that is something that I kind of need to circle back up with investors and say, like, are you making materially different decisions, based on this, and how deep do you, if they've got, a stable of, 50 engineers, or developers, and 3 of them, are, moonlighting, and they're all, juniors at Stanford, and they come and they're Chinese nationals. Like, is that a problem? And kind of back to, yeah, it is. It's a problem. And so, and the problem is
in certain fields, you just can't do it domestic. I mean, quantum comes to mind, which I'm sure is on the list, right? And quantum is, at the moment, it's a multinational effort. I mean, a lot of it's happening in Sweden, a lot of it's happening in Canada, a lot of it's happening here, some of it's happening in China, and I'm not sure how connected that part of it is to the rest of it. But but the U.S. effort and the companies that are doing this from the U.S. are certainly it's a multinational effort to get to functioning quantum computing.
It is. That is one that seems to be really divided. There doesn't seem to be overlap on the quantum side. I mean, quantum has kind of been put out there as like, if you win quantum, you win, like, world domination. I mean, that's I don't know how true that is. My husband actually works at a quantum company. They just came here from Australia. So he's not Australian. But it's really interesting. That seems to be kind of the stake that's out there. And so as far as I've seen, that's one where it's very top of mind. But then you've got AI and you've got data analytics, all the other stuff, natural language processing, autonomy, right? All these things. I mean, I was actually with an investor not too long ago, and he literally whipped out the supply chain in F-35 and had highlighted all the components that are made in China. That's a problem. And the problem is that that people aren't aware of this. And so I feel like a fearmonger sometimes. I don't mean to, but this is a bigger problem than I think anybody really realizes. If anyone's read Kill Chain that I have right over here, just read the introduction. If you don't, just get to the introduction, and it pretty much outlines, what, again, kind of how our face of war is changing. And so I think for us to be lackadaisical, and I was actually talking to our high level, I won't name names, but somebody over at Stanford, who's very privy to numbers of students and where they come from and that sort of thing. And I said, we can't just be letting in, 60% of Stanford's incoming freshman computer science class are Chinese national, 60%. And that's a problem. And so, and at first the sentiment was, well, it's our job to, attract the best and the brightest, and it's up to you guys and your government people to, keep out the bad actors. And I said, well, the problem is it's not like it's a bunch of spies or a bunch of bad actors, but the problem is when they go back, there are certain, entrance, exit exams that they take, and they disclose things that they learned. And so it doesn't mean they're inherently bad people. They came here to get an education.
And they can be impressed, in the old naval terminology, they can literally be impressed into the defense marketplace of technology inside China. But that's okay, because guess what? You may or may not know this, but UT Dallas's computer science program is actually way better than Stanford, and nobody in China knows that unless they're listening to me right now. I think the great outcome of all of this really is the awareness and the focus. Whenever you realize the supply chain on the F-35, when you realize that in the drone space, which was the first trusted capital marketplace tech event, DJI controls everything. But in response to that, you have guys here in Austin like Colin Gwynn, who is launching the Center for Autonomous Robotics, and the whole purpose of that is to create a place, a collaboration and product development and testing place where you actually can do what DJI does, which is to rapidly prototype, test, and iterate drone prototypes, so that you can get you can get iterations in the field super fast, and therefore make them super cheap. Because that's not the way these technologies are produced in the United States today. But efforts like that are going to change, so that the national security innovation base 10 years from now is going to look drastically different. Just hopefully we won't fight any big wars between now and then until we catch up, right?
Yeah, we need fire. We need fast in 10 years.
Although I'm pretty confident in our nation's military's capability to take on any adversary today, and I will remain confident that we'll still be there in 10 years, if not farther ahead, because of the efforts that we're making. Efforts a lot in a big way, Heather, you are helping to spearhead. So thank you very much. On behalf of our Defense Academy audience, I really appreciate you being here today, presenting to our audience. Great questions, great information. You guys will all get the slides, and hopefully we'll see you.
Great. Thanks, you guys. Thanks for having me. Appreciate it.
All right. So that is it. Hey, Brian, throw yourself up on stage if you can. I want to thank Alamo AFCEA, our community partner. They were critical in getting some of the content to you and getting the word out. So thank you so much to them. We look forward to seeing Alamo AFCEA's participation in further events. So let's see. Brian, you want to take this one away?
Sure. So, guys, we have the job fair coming up. I touched on that yesterday. Going to send all the information out, the recap email as well. I sent out the Eventbrite. It's going to take place on August 27th, and that's relevant to you if you're hiring for your startup or you're job searching. And then, Kevin, do you want to take away the Cyber Accelerator?
Yeah, absolutely. If you're applying in the 20.3 cycle on the AFWorks open topic, then please also apply to the SBIR Accelerator. The entire focus of the SBIR Accelerator is to take a Phase 1 award-winning company on the AFX open topic, and during that Phase 1 period of performance, we're going to help you find three things. We're going to help you find a DoD customer to be your MOU signer, as well as additional DoD customers potentially from other services that would sign letters of support. But we're going to help you make those connections. We want to help you find an industry partner in the defense or commercial industry that's going to help you demonstrate commercialization, and particularly if it's a defense industry customer, that's going to help you tailor that product to something that's going to land into a program so that you can show that Phase 3 potential to the to the AFWorks review team. And then the third thing is investors. If you are raising capital, having those letters of intent from an investor are going to be critical to demonstrating the market validation of your technology. All of that is intended to help you produce the best phase 2 proposal that you possibly can. And hopefully, depending on how the Air Force goes on what they used to call matching funds, and I'm not sure what we're going to call them going forward, whether it's the, I'm going back in the recesses of my brain to Russell's SBIR deep dive on Monday. The TACT-FI is potentially taking the place of matching funds. But anyway, whatever that is, this accelerator program is designed to help you build the proposal that's going to make you competitive to go get those additional dollars. I also want to thank especially, and this is why I asked Brian to come up, Brian Hiddle. Brian has been instrumental in keeping this program on track, getting all you guys into it, getting the content, arranging and wrangling all the speakers, making sure they were able to connect to the technology, which he was, I think we're going to say 91% effective at, because we only had one person that didn't get connected. But thank you very much, Brian. Thank you very much to all of you who attended. I think that's probably our last slide, unless we just have a slide that says Capital Factory is awesome.
Yeah, so one last thing, guys. We have Austin Startup Week coming up. That's October 5th through the 9th, and that's kind of our next huge event that we're a part of. So stay tuned for that, and more information coming out in the recap email. Let's go to the next slide. Also, we want you to stay involved. We have a ton to offer. We love our Defense Academy audience, and we're ready for the next edition of Defense Academy. I'm already looking forward to it. Sign up for our newsletter. Information on that's coming out. Twitter, CF Defense. Great content. Become a virtual member. I know you guys have seen the information and the recap emails that I've been sending out. So we have a ton to offer, a lot of deliverables there. Apply to our accelerator, and I'll send a link in the recap email, and then Kevin touched on our Sober Accelerator also, and then also becoming a mentor so you can take place in awesome programs like Epic Office Hours. So we have a ton of resources coming your way. And then also I just wanted to thank you for attending. Again, my name is Brian Hiddle. I'm the program coordinator here at Capital Factory. Hit me up on LinkedIn. And looking forward to the next time that we all get together for Defense Academy, and I hope everyone has a great weekend. See you next time.